I wanted to start by saying that I'm a member of CAST. Has anyone ever heard of the CAST? C-A-S-T, large capital letters. I would behoove you to go ahead and take a look for that, do a Google search for this organization. They produced a white paper, and anyone that even deliberates on this topic of pesticide use and its role in agriculture needs to read this white paper number 55, CAST issue. They're written for our legislators. It's a think tank actually out of UC Davis, situated in Washington, D.C. I've been a member for 4 years, and I use that as fodder for everything that I teach because they do such a great job. And so this issue paper number 55, the contributions of pesticide to pest management and meeting the need for food production by 2050, is an excellent background read, and I think anyone that even thinks about this topic needs to read such papers like this out of this organization, the Council for Agricultural Science and Technology, CAST. So anyway, what I have before me is some slides here, and we got to get right into chemistry. I'm going to teach you about the chemistry of this product, Chlorpyrifos, and why it has utility and continues to have utility. A previous lifetime, a previous career, I was just talking to Errol, I was a dairy farmer at the Naval Academy Dairy Farm as an agronomist for 18 years. So while I was an undergraduate at Maryland, I was practicing the craft as a full-time employee eventually at that facility, and then led the cropping production as a crop master and agronomist. So I have used a lot of Lursban or Chlorpyrifos in a lot of different capacities, and even going into my research at the University of Maryland, I still use the product. It still has great utility. And I look at pesticides as, I like to think of them as kind of a economic or strategic poison. That's the truth about pesticides. Their job is designed to control pests. Pestilence is not something that we should ignore. And I think the pesticides are these chemical tools. And here before you, this is not a country, Iraq. This is the Resistant Action Committee, Iraq. It stands for the Insecticide Resistant Action Committee. And you can see that group of blue. I know you can't quite see all those chemical compounds, but what I want you just to visualize, if you will, each one of those little hexagonal squares there represent some compound that's critical to agriculture, and this is insecticides. And we have the Fungicide Resistant Action Committee, we have the Herbicide Resistant Action Committee, and I'm a weed scientist and a lot with herbicide physiology in the past. And so, but with insecticides, okay, very good. I need to be closer. So if you look at those blue colors and that first block, I don't know if I got a pointer here, right there. I can't see it showing up there. That's it. Well, the blue boxes, the one at the top, are the organophosphates and the carbamates, and we still have a quite extensive group of. See it working? Okay, not showing up on the screen. Interesting. Anyway, so we've got this group, and what I want you to realize is that within this Resistant Action Committee, the goal is to look at mode of actions of chemistry, and they have this, I really like this slide particularly for teaching mode of actions. And you'll notice that nerve poisons, anyway, those blue boxes represent the nerve agents, if you will, that we use as insecticides. And interesting enough, the ones that we've really based most of our insect control on are these nerve agents. And the pyrethrins are nerve agents. And interesting enough, DDT is in that family of chemistry that acts similar to pyrethroids. So we have high tolerance for DDT. We have high tolerance for pyrethroids. We have the organophosphates and the carbamates represented as nerve agents. And we have right now the neonicotinoids and the spinosins, all very common chemistry used in agriculture now that fall in that realm of nerve agents. And it behooves us, I think, to know what a nerve agent does in relationship to trying to kill an insect, and then in response to even our own physiology. When we talk about chemistry, all those pictures you see, that's organic chemistry, right? We are organic life forms, and everything that we're trying to oppose, if you will, with chemical tactics are organic life forms. And so in order to do that, we have very strategic tools, very chemical strategic tools for that purpose. And so insecticides predominantly are nerve agents. If we go back to that mode of action, we do have other insecticide classifications. BT acts on the stomach or gut. It's a mid-gut poison. But they're all poisons in some capacity to target specific pests. So if we look at this slide here, you'll notice that we talk about cholinesterase inhibitors, this group that the Chlorpyrifos falls in. And they actually work at that synaptic cleft, and they are basically an inhibiting enzyme that's necessary for that acetylcholine molecule to come off that receptor site through this enzymatic process. So we go in the neuron, we have electrical impulse down the axon, the myelin sheath, the sodium channel, and these different, and we have chemistry like pyrethrin actually work in that capacity on the neuron. So it's very important, I think, to understand the function of this chemistry and then how we use it cleverly, if you will, in agriculture to combat pests and not poison ourselves, right? And so that's been the kind of the battle, if you will, the lifelong battle that we have is every farmer has to become a better farmer. And the reality is that's not going to be any different tomorrow. You know, every farmer will have to produce more crop, they'll have to produce it economically, and they'll have to use pesticides or some other strategies like genetically engineering the crop to produce their own pesticides. The cholinesterase inhibitors are actually natural in the natural environment. So I always say that chemists don't just magically pull these chemistries out of the sky. They find them through discovery, and they typically find them through discovery in the natural world. And the cholinesterase inhibitors actually, there is a natural plant that actually, if you review this subject, you'll find that they actually derive some of these natural substances, and right now one of the best Alzheimer's treatments is a cholinesterase inhibitor that comes naturally derived botanically. So it's not, these aren't mysterious chemicals, right? These are chemicals that are around us in the natural world. We have adopted them and been able to synthetically produce them or reproduce them in the laboratory and then go out and use them as chemical tactics, in this case nerve agents, to hopefully destroy insect pests. And that's a really, really important to think about. Lorsban has been used, I just put Lorsban up there as the most major labeled product of this product, Chlorpyrifos. You'll notice it has a warning label on there, and I'll show you a little bit more about that. It is restricted use because it is somewhat dangerous, and that restriction warns our farmers and those that use it to use it correctly and by the label. You'll notice all those crops up there, every one that I have highlighted in yellow has more than currently, and this is the most current EPA document that I could find. I think it's up to 2006, I think. 2009 is when it was written. But you'll notice that those crops on there are pretty substantial in number. There's 61 listed there. And there's a number, I didn't count the number in yellow, but at least a third or more are over above 50,000 pounds of product used annually in the U.S. So very substantially used. But historically, this is a downward trend. If we go back into the 80s when I was using these quite a bit, and I used them on most of those crops there, alfalfa and soybeans and on most of the tree fruits and grapes, and I've used them myself on all those crops, sweet corn, sweet potatoes, and so wheat, and I've used this product over the years in a number of different crops that I've worked on, and I see the utility in the product. If we look at the historical toxicology of and I'm not a toxicologist, so I don't even profess to be that, but I do know that this product does break down in the environment fairly readily. It breaks down in the air very rapidly. Within a few hours, actually, most of it is actually broken down by photolysis and interaction with oxygen. The place where it breaks down the least is in the aquatic environments. However, if we look at the ability of this product to persist in the environment, it has a very high K coefficient, which means it's absorbed very tightly to clay particles in the soil and organic matter, which means it has to pretty much wash off with the soil in order to get into the watershed. So short of direct deposition into the watershed, and we don't typically use this for mosquito spraying anymore. This was product we historically used, but we don't typically have, I would think, much interaction. And if you look at the FDA drinking water reports, you'll find that there are extremely low level, if not at all, detections of this in most watersheds. So again, it doesn't surprise me. Even though we use quite a bit out in the landscape, it shows up very low levels. Not completely undetectable, but very low, and certainly well below tolerance settings. Interesting enough, I teach this concept of LD50, lethal dose that kills 50% of the test population, based on milligrams per product on kilograms of body weight. And Lorsban falls in around 300 technical level. There are some debates as to the range, whether it's between 96 and 270, but 300 is what's reported. It has been reported since its inception in 1974 when we first saw the product come into the marketplace. You'll notice that if you look at those acute LD50 values, orthene is one of the more toxic ones, but it's still much less toxic than the compounds we previously used, and I'll show you a slide of that in a minute. But if you look at the common ones there, orthene, capture, baythroid, lorsban, and the chemical corresponding chemical names, you'll see that the permethrins and even malathion, which is organophosphate, are very high, and so we have moved towards safer products. And so I think that's the trend I'll show you here in a minute. But you can actually calculate, and I do it all the time, what's a lethal dose that might kill me, and there's my lethal dose there of Chlorpyrifos. In its formulated form as lorsban 4E, it would take 50 Tylenol tablets corresponding in weight or milligrams, essentially, and really 12 Tylenol will kill you anyway, right? 12 Tylenol can put an adult in liver failure. So it's less toxic by far than Tylenol. And so I think that's kind of insightful. This idea of it had a warning label, remember? So if caution, a signal word, would be somewhere between 50 and 500. And we think 300 would be the range where we would see on that warning slide there. So it's in that range. The other thing, and this leads back to some of this degradation pathways here, this whole it's really exciting science about how chemicals break down in the environment and how fast they leave us alone, right? And about 28 days is considered the half-life and probably within at least 2 months there probably wouldn't be any detectable levels the way I read the science there. And it is highly emulsifiable, which means it's purely water-soluble. That's true. However, that K coefficient, that value I was talking about of 8,151, means that it is very tenaciously held by the soil. Okay, and so again, most of our applications are to the soil or to the crop and end up in the soil, less likely to leave that field, okay, given that type of chemistry, and quickly to break down. Here's some pictures of the crops here in Maryland that lorsban has been applied to and that I have worked on, these crop pictures that I've taken, most of the research and things. And right now, it's if we look at Chlorpyrifos and its use rate, it's still a major player. It's ranked around 14th right now in the U.S., so it's still a very heavy hitter out there in terms of use, and we saw that in that earlier slide. Although it's on a great downward trend. It's been on a downward trend since the Food Quality Protection Act of 1996. And so we've seen a lot of labels that were lost that used to be at the homeowner level. We used to, if you can remember back, we used to use a product called Dursban. We sprayed our cats and our dogs and our bedding in our homes, and we treated everything. And when this product left the marketplace, along with diazinon, we actually had a ramp up in bed bug problems because of resistance to pyrethrin. And it's this resistance that's really critical, because we really want to make sure that we have all the tools in the tool chest, that we don't take any away, and that's a real critical thing with this. So we do see, if we look at the downward trend from 2000 to 2012, yeah. 33, we've gone from 71 to 33% in organic phosphate use in this period of time. And bear with me, I'll speak up. But this downward trend is something because of Food Quality Protection Act 1996 that Clinton administration put into existence, and so we see from 2000 where we were almost 70%. Was the organophosphate. We now have probably down to only about a third, right? So again, that's very graphically visible. You also in this graph here, you'll notice that if you look at the Food and Drug Administration Market Basket Report, how many of you have looked at that report? I like to look at that report periodically. This is the most recent one. Chlorpyrifos levels and overall detects. They're certainly there, mainly in fruits and vegetables. You see those blue bars as being quite high. That's where they detected pesticide residues. However, if we look at violations, very little violations in the U.S. In that case. And the violations typically can be off-product, mislabeled products. They don't necessarily mean that it's a product that has been used at too significant of a level. And if you look at Chlorpyrifos summaries, basically they have a wide range in acceptable thresholds, but most of the time, very limited detections if you look at the literature and quite review out there. So I think we're doing a good job as far as using the product correctly in agriculture and limiting the amount of residue that comes into the marketplace. And I think that's really key. And we can do that with this product. I just want to realize that when we think about words and letters and chemistries and elements, we're just beginning really to understand the chemical world. We've really only been at it since the late 1800s in any really significant way.
But I like to think of pesticides as kind of a plant medicine approach in IPM and prescriptive. And I think Lorsban, Chlorpyrifos, still has, and this whole group of organophosphates still has a very important role, a very significant role in our current agriculture system. And I do believe that FDA and EPA do an amazing job of putting together very comprehensive scientific reports and under very good review. So I always go to EPA and FDA and USDA for these reports because I do put great confidence in these reports. And if anyone spent the time reading them, and you can spend the time reading 300 or 400 pages of this about this product and the latest review that they did on Chlorpyrifos, I think you'll realize that these things aren't taken lightly. And so farmers do need this product. I didn't mention all those crops that we saw. Some of those things, like peach borer, I know Robert Black, he says, make sure you mention that. You know, Lorsban controls peach borer, nothing else does. You know, so if you want peach orchards in Maryland, you need Lorsban right now. That's our tactic, okay? And so again, there are crops like that, alfalfa. A lot of the crops where it's heavily used are feed crops, not food crops, and that's also important too, going into our animal and also securing our grains and things in our bin. We do no longer use Chlorpyrifos in grains, but I can remember when we used to dribble Reldan on every bit of grain, every bushel of grain that went in storage. So we have been moving away from a lot of these organophosphates that we historically have used. And so that would be, there's a lot more we can get into the science, but I think I'll go ahead and pause there and turn it over to my colleagues.
We'll see if my microphone is working. Can everybody hear me? All right. So good morning, everyone. My name is Lindsey Thompson, and as they said, I have a consulting company where I provide government relations and association management services to agricultural and natural resource nonprofits. So I had just figured out how to pronounce and spell neonicotinoids when Chlorpyrifos came on the scene. And so I've spent about the last 2 years kind of getting up to speed on the regulatory and policy aspects of Chlorpyrifos. As you heard, Chlorpyrifos was first registered in 1965 by the Environmental Protection Agency and has been re-registered every 15 years since, or at least every 15 years since. So pesticides are governed by the Federal Insecticide, Fungicide, and Rodenticide Act, which I will call FIFRA. This act outlines the process for not only the registration, but also the distribution, sale, and use of any pesticide product, and that includes herbicides, fungicides as well. So the registration review process includes a series of risk assessments that evaluate the potential for the harm to humans, wildlife, aquatic organisms, plants with a special consideration for endangered species, and then also non-target species, as well as the contamination of surface and groundwater. Through that process, registrants or a company, so Dow Chemical was the initial registrant of Chlorpyrifos, now known as Corteva. Registrants do provide a substantial amount of data from independent research on the potential risks of these pesticides to the aforementioned constituencies. But EPA conducts their own risk assessments, gathering of different studies, and that is peer-reviewed through the process. FIFRA was amended in 2003, actually, to strengthen the legal emphasis on protecting specifically human health and the environment through the potential contamination of water. So the initial registration as well as the re-registrations are going to include evaluation of those risk assessments and peer review, and the purpose of all of that is to establish what is known as a level of concern, right? And any measures that are required to mitigate it and meet that level of concern threshold. Establish the food tolerances. So you heard Dave talk about residues. So there are tolerances or levels of concern that are set for food residues. Craft the label. I always say the label is the law. A label for a pesticide can range anywhere from 3 pages to 30 pages, right? I don't know how many pages dicamba is these days, but they keep redoing that one over and over. and the label and the registration, if it is approved through the process, is then published into the Federal Register for public comment. I didn't use slides because, as you can tell by now, there's nothing visually interesting about anything that I'm going to say when it comes to pesticide regulation. But all of that is to say that there is a very intense and arduous process at the federal level that includes EPA, USDA, and FDA. It takes an enormous amount of resources and a very long time for a pesticide product to go through initial registration and come to market. So in 1996, you also heard Dave talk about the Food Quality Protection Act, and that set more stringent standards, specifically talking about the protection of children's health. And so after concluding the re-registration review and risk assessments for chlorpyrifos in 2000, EPA determined that there was a need to modify certain uses in order to meet these new standards. And I think it can become confusing sometimes. So it's not that anything about chlorpyrifos changed, right? The standards changed. So I remember, I think I was in like elementary school, and all of a sudden we had to start drinking water out of the water coolers. We couldn't drink out of the water fountains anymore, and it was because the tolerance for arsenic had changed, right? And so we had to go through these changes with the water system to meet those thresholds. But I had still been drinking that water before, right? So it's not anything about the water change. So same kind of thing happened here, right? This ultimately resulted in Dow Chemical entering into an agreement with EPA to voluntarily cancel the registration for most homeowner uses. At the time, you could still get ant and roach bait if it was in child-proof packaging, right? But they canceled all of the uses for things like termite treatment, bed bug treatment. And it also changed the application allowances for a lot of your fruit crops and your orchard crops, where they would only be applied during a dormancy period, and that was to meet those food residue tolerances. So moving forward to 2007, there was a petition to EPA to revoke all tolerances for chlorpyrifos. And that triggered another arduous process of scientific review, right? So in 2011, they produced another preliminary human health risk assessment. And this is within that 15-year period. So it was re-registered in 2000. We're talking 2011, so not quite 15 years at that point. In 2014, there was another lawsuit against EPA for not making a decision on the petition from 2007, right? And so the court ordered that they were to make a decision by October 31st, 2015. So in 2014, they released a revised human health risk assessment, and still didn't make a decision. So that, am I stealing some of your thunder? I'm sorry.
No, this is fine. This is all very helpful background. Thank you.
So the deadline was extended to March 31st, 2017. Another revised human health risk assessment was released in 2016, intended to address concerns about the use of some epidemiological studies, which I'm not a scientist and I do not claim to be, but my understanding is that they are only intended to demonstrate evidence of a risk factor correlation, not causation, associated with a higher risk within an exposed population, right? So there was some controversy over whether some of those should be used. But ultimately, as a result of that risk assessment, I thought this was interesting. So USDA, Office of Pesticide Policy, under the Obama administration, submitted comments when that human health risk assessment was submitted to the Federal Register. And I'm just going to read you an excerpt from that. So USDA has grave concerns about the decisions that have led EPA to publish 3 wildly different human health risk assessments on chlorpyrifos in the span of just 2 years, and severe doubts about the scientific validity of those conclusions, and ultimately called on EPA to deny the petition and allow chlorpyrifos to continue through that process. No decision was made when Obama left office, and I'm going to let Jason cover everything that happened there. But really quickly, I'd just like to talk about what's been happening in Maryland. So in the 2018 legislative session, Senate Bill 500, House Bill 116 proposed to ban all uses of chlorpyrifos specific to the state of Maryland, right? It was ultimately unsuccessful, but it did raise a variety of very interesting issues and conversations. So Dave showed you the nationwide use of chlorpyrifos. Based on the most recent pesticide use survey specific to the state of Maryland, which is conducted with NASS in partnership with the Department of Agriculture, about 4,000 pounds of chlorpyrifos per year are used in Maryland. And that is a precipitous drop from previous, because you heard Dave say again, it's very rarely used in grain crops anymore, right, which is the primary land use for agriculture in Maryland. Still used in some non-GMO corn that doesn't have that BT in it to resist the soil pests, but primarily used in vegetables, fruit, and orchard settings, right? And so talking about what we heard in the legislature as some of the potential consequences if it is banned in the state of Maryland. Peachtree borer, Mr. Steve Weber said, I have to use this only when I have to, but it's the only thing that I can find that I can control peachtree borer, or I'm going to lose my peach trees, right? There is a farmer over on the Eastern Shore. They have a contract with a vegetable company to grow peas and lima beans. It's used as a seed treatment on their lima beans. Well, the company decided within their contract to ask them or require them to use a different seed treatment. It was a neonicotinoid. That year, they experienced upwards of 30% loss pre-emerge on those lima beans. And so this year, they went back to using chlorpyrifos. So there's not that many effective alternatives for the very specific uses that chlorpyrifos is being used for. And it's not used often, it's used only when needed, but the people that are using it right now without any effective alternatives do really need that. And another question that state-level pesticide legislation always brings up is, should pesticides be regulated at the state level? So you heard me talking about this very intensive and arduous statutory process at the federal level in place to regulate pesticides. And there's arguments definitely on both sides of the debate with states' rights, of course, but some will argue that state-level pesticide regulation creates this patchwork and confusing regulatory environment for farmers. A lot of our farmers farm in Maryland across state lines, right? So it becomes difficult when you are buying seed to say, oh, I have to buy different seed for Maryland than Delaware. And so that is a potential concern. And something that brings up is preemption, right? So there's 28 states that have expressed preemption where the state cannot regulate pesticides outside of the federal level, right? And then there's varying levels of preemption. There's implied preemption or state preemption, considered field occupied, where localities cannot regulate pesticides. So it raised all of these issues. One point that I do want to make is that risk is a factor of exposure, right? So a pesticide cannot be inherently dangerous unless you are exposed to it at a level that is above that LD50 or the risk concern or the level of concern, right? It doesn't have to kill you to be concerning, right? There are other unintended consequences, but it is a matter of exposure. So the primary concern of advocates for revocation are the impacts of chlorpyrifos on neurological development in children based on an epidemiological study or series of studies, the most famous of which is from Columbia University. That is the primary study which caused some of the contention with the human health risk assessment, although it is not the only study in that body of evidence, right? So there are these competing bodies of science on what is the risk of chlorpyrifos. UC Berkeley and Mount Sinai, both very reputable universities and hospitals, conducted similar research and were unable to demonstrate that same length. So I'm going to leave you with, FIFRA is the statutory process through which registration does and has occurred for decades at this point. EPA, USDA, FDA have the resources and expertise to continue to implement that statutory process, and those decisions continue to be made at the federal level. And so that's just a consideration as to whether or not individual states have that same level of knowledge and expertise available.
Mine works. Thanks, Lindsey. I'm Josh Siegel from the Maryland AG's office. I'm one of a number of attorneys in our office who have worked on various aspects of litigation over federal regulation of Chlorpyrifos. I actually came to the office when the litigation was well underway, but my hope is that I'll be able to provide all of you with some useful background on how we got here in the litigation and what might lie ahead. Lindsey, thank you also for providing much of the complicated legal background that I otherwise would have had to provide in order for the remainder of my presentation to make any sense. So, as Lindsey said, FIFRA is an important operative statute here. There is also the Federal Food, Drug, and Cosmetic Act as amended. I'll call this the FFDCA for short, and I will try not to be too acronym heavy otherwise. The FFDCA establishes that although a food with pesticide chemical residue is unsafe and cannot move in interstate commerce, EPA can establish limited tolerances for particular pesticides so that they can move in interstate commerce. The FFDCA also sets forth what it means for a pesticide to be safe. Namely, EPA must determine that there is a reasonable certainty that no harm will result from aggregate exposure to the pesticide chemical residue, including all anticipated dietary exposures and all other exposures for which there is reliable information. In addition, when it comes to leaving a pesticide tolerance in place, EPA again must ensure that there is a reasonable certainty that no harm will result to infants and children from aggregate exposure. And FIFRA, of course, covers the registration side of a pesticide, and sometimes pesticides are registered differently for food uses and non-food uses. The upshot of all of this, as relevant here, is that if EPA revokes a pesticide tolerance under the FFDCA, then it also has to revoke the pesticide's registration for food uses under FIFRA. So, with respect to Chlorpyrifos, as Lindsey said, the real action has begun to take place since 2007 when petitions for review and revocation of the tolerances for Chlorpyrifos were filed with EPA. And over the subsequent years, there's a whole lot of back and forth involving scientific studies, reports by EPA's scientific advisory panel, several trips up to the Ninth Circuit Court of Appeals on the West Coast because EPA had not acted yet. Ultimately, in 2015, the Ninth Circuit Court of Appeals ordered EPA to respond to the petition. There was then a report issued by EPA's scientific advisory panel agreeing that there is evidence of adverse health outcomes in young people associated with low levels of exposure. EPA then proposes to revoke all food tolerances for Chlorpyrifos. That's in 2016. But then, as Lindsey said, when we get to 2017, EPA denies the petition, so it's finally taken the action on the petition that the Ninth Circuit had urged EPA to take, rather than delaying further. And in denying the petition, EPA says essentially that the science remains unresolved and there's a need to evaluate the science further to achieve greater certainty. And EPA proposes to do this by 2022, which at that point would be 15 years from the date the petition to revoke the tolerances had been filed. So a group of NGOs as well as a group of states sought review of the EPA's decision in the Ninth Circuit. At the same time as they sought review of EPA's decision in the Ninth Circuit, they filed administrative objections before EPA. And the case proceeded in the Ninth Circuit with the government asking the court to dismiss for lack of jurisdiction because EPA had not yet ruled on the objections that had been filed before it. About a year after the case was filed in the Ninth Circuit hears argument. Shortly afterwards, the Ninth Circuit issues a decision, and at this point, EPA still has not ruled on the objections, and the Ninth Circuit, I think it's fair to say, is concerned about the delay that it's seen. The Ninth Circuit says the EPA has stalled on banning chlorpyrifos, first by largely ignoring a petition properly filed pursuant to law seeking such a ban, then by temporizing in response to repeated orders by this court to respond to the petition, and finally, in its latest tactic, by denying outright our jurisdiction to review the ultimate denial of the petition, even while offering no defense on the merits. If Congress's statutory mandates are to mean anything, the time has come to put a stop to this patent evasion. So those are fairly strong words from a federal court of appeals. The Ninth Circuit holds that there is no jurisdictional requirement in these circumstances that the petitioners wait for rulings on their objections before they can get a ruling from the Ninth Circuit on the denial of the petition. Ninth Circuit stresses that the petitioners have acted diligently, that the case involves primarily legal questions, and that further delay would prejudice the plaintiffs. Having established that it has jurisdiction, the court turns to the merits of the question before it. It notes petitioners' argument that a need for additional scientific research is not a valid ground for maintaining a tolerance that, after 2 decades of studies, has not been determined safe to a reasonable certainty. The court says EPA bears a continuing obligation to revoke tolerances that it can no longer find with a reasonable certainty are safe. And the Ninth Circuit then looks to the fact that the 2016 risk assessment, whatever amount of debate there may have been over it, included a conclusion that expected residues of chlorpyrifos on most individual food crops exceed the reasonable certainty of no harm safety standard. And the Ninth Circuit also stresses that in denying the petition, EPA hadn't found a reasonable certainty that the tolerances were safe. Rather, what EPA had found was significant uncertainty as to the health effects of chlorpyrifos. There is a dissent in the case. The dissenter says that the provision allowing the Ninth Circuit to review certain EPA decisions is jurisdictional insofar as it requires petitioners to file objections with EPA and then wait for a decision by EPA. With respect to relief granted to the petitioners, the Ninth Circuit, and then this is back to the majority and not the dissent, of course. The Ninth Circuit orders EPA to revoke all tolerances and cancel all registrations for chlorpyrifos within 60 days. The court then clarifies subsequently that that 60-day period does not begin running from the date of the decision. Rather, it begins to run from the date the court issues its mandate, which is sort of in comic book terms, the date that the Court of Appeals decision really becomes real and binding on the parties before it. There's a rehearing petition filed by EPA seeking rehearing either by the panel or by the full en banc Ninth Circuit. That rehearing petition remains pending. Again, the mandate has not issued yet because the rehearing petition remains pending. The court has called for a response to the rehearing petition, which has been filed by the NGOs. I want to come back to the response in a moment. I'll also note that several amicus briefs or friend of the court briefs have been filed in support of rehearing en banc by a variety of industry groups. They raise questions such as whether the court's jurisdictional ruling was correct, whether the court should have, instead of ordering EPA to take certain steps, just kick the matter back to EPA with instructions to proceed in accordance with sort of broad principles set forth in the opinion. And then there's a further argument that's made that the affirmative relief that the court granted, even if some aspect of it were proper, was nonetheless overbroad because EPA can't just snap its fingers and cancel a registration, number one. That's because EPA has a statutory and regulatory process that it needs to go through in order to cancel a registration. And number two, there's an argument made that even if revocation and or cancellation were proper as to non-food uses, the standard for food uses of a pesticide is not this categorical, you must find a reasonable certainty of safety standard that applies to food uses. So in that sense, the argument is made the Ninth Circuit's decision was overbroad. The NGOs, in their opposition to rehearing, interestingly conceded that cancellation had gone too far in extending to non-food uses, and also conceded that cancellation, if it went forward, would indeed have to take place pursuant to the statutory procedures and deadlines that had been noted in the rehearing petition and amicus briefs. So there's no specific deadline for the court to act on a rehearing petition. If it grants the rehearing petition, there will be likely further argument before an expanded panel of 11 judges. There will probably be more briefing as well. Whether or not there is a grant of the rehearing petition, it's quite possible that there will be a petition for certiorari filed with the United States Supreme Court asking the Supreme Court to take the case up on the merits.
We are going to open it up for questions. I'm assuming there's going to be questions. Start over here.
I just had a question. You lost me way back there on some of the stuff you were talking there at the last, but something you said there at the very end, talking about the food uses versus non-food uses, and that there was a look that there might be just a ban on, or some sort of ban on just the food uses, but allow. Are you talking about, so like the golf courses would continue to be able to use it for that type of thing, but an orchard that is using it on the trunk of a tree during the off season when there's no fruit being produced, that would still be banned because it's a fruit tree?
So I'm not sure about off-season uses, but my understanding of the arguments is that, at least at a high level, yes, there's a distinction between golf courses on the one hand and apples on the other.
Yeah, so the distinction is that they conceded that the cancellation of non-food uses went too far because there was not precedent for that under the legal standing with the Food Act, right?
Right.
Yeah.
Right. That and in essence, the standard for and criteria for cancellation of registration as to food uses is different under the statute from the standard as to cancellation for non-food uses.
I would ask, is that a separation between feed uses and food uses? Because a lot of the products are used for feed, animal feed, that go into the animal feed system. And so is feed food? That would be my question first.
That's a good question.
I don't know the answer to that.
Other questions?
Two questions. One, what is Maryland's position in the litigation? And two, if you grow food in Maryland and you have applied Chlorpyrifos and you export it to a country that has banned it, can you export it?
I guess.
Position, and I can take.
Yeah. So as to the second question, the answer is I don't know. But it sounds like Lindsey may have an answer to that. Maryland's position is that Maryland is part of a group of states that have intervened on the side of the NGOs in the litigation in the Ninth Circuit.
And then as far as the utilization of a pesticide on a food or feed crop for export to a country that has banned the product, all of the food must go through the residue testing, and if it doesn't meet the threshold for safety within the residue testing, it's not going anywhere, right? But think about grain going to the European Union, right? So for certain uses, neonicotinoids are no longer allowable in the European Union, but that does not impact the allowability for a United States grower to use a neonicotinoid as a seed treatment, grow that crop, and export it.
That last question happens to be my area of legal practice, and the answer is you have to meet the requirements of the receiving country.
Mm-hmm.
I would just add that no farmers segregate their products based upon the use of pesticides that I'm aware of,
Unless it's organic versus
unless it's organic versus non-organic.
Other questions?
So this presentation was really helpful, but I was wondering if you could speak briefly to the legal landscape of pesticide regulation in relation to things other than human health. That's a very important aspect of the issue, but I'm thinking specifically in terms of broad spectrum insecticides like organophosphates, and their effects on pollinator populations, especially in relation to the huge declines that scientists have been recording over the past 3 decades. Yeah.
It goes back to that resistance management that we talked about when we had different modes of action. And Chlorpyrifos is actually kinder to the pollinators than the neonicotinoids or the pyrethroids. And so, again, it's a tool in the toolkit when we look at choosing wisely when we think about diversity of habitats and things, that managing different modes of actions becomes very important to other species. And so I would say that would be a loss to lose the organophosphates in this management of IPM and trying to have diversity of species in the landscape.
And so pollinators would be also considered one of the non-target species that are evaluated for risk within the registration, re-registration, and risk assessment process. And EPA does have and has demonstrated their right and ability to make specific label changes for pollinators. So most recently with neonicotinoids, they have a specific provision on the label that says you may, or that sets time limits. You must apply it at times when pollinators are not foraging, and you must check for the presence of foraging pollinators and not apply during a bloom. So they do have that ability to try to mitigate the risks if they do find that they exist.
One other example of the use of chlorpyrifos in the off-season would be we typically use a dormant spray early in the year before bud break. It's very important in mite control as well as scale control on our fruit trees. And so these applications that are long away from harvest and will be no residues detectable at the time of harvest are still very important in the agricultural sector. And having the different chemical families, again, again, we typically talk about resurgence of pest and unintended consequences. Every time we do put a pesticide in the environment, there's always some unintended consequence. And a lot of the pyrethroids especially will cause mite flare-ups in a dry summer period. Now, we didn't endure a dry summer this year, but I have seen where you put on a pyrethroid application and then all of a sudden have a mite population that is out of control. The chlorpyrifos used early can avoid that complication.
Any other questions? Okay. Well, again, please help me thank our panelists.